Okay, well, good afternoon, everyone. Welcome. My name's Alex Finley, and I'm chairing today's EIG webinar, which will be given by Stephen Hadley on minerals, a legal perspective. Just a few notes before we start. First of all, I'd like to let you know that our conference will be going ahead in a virtual form in November, the first week of November. Further information on this will be coming out before too long. Also, all previous webinars and this webinar will be available on our website and YouTube channel, and there's a link to this I've put in the chat box. Today's talk will be approximately 30-40 minutes, giving plenty of time for question and answers afterwards. If you do have a question, please could I ask you that you type it into the question and answer box rather than the chat box. This makes it a lot easier for Clive and myself to keep track of them. And with that, I'll pass over to Stephen.
Thank you, Alex. My name's Stephen Hadley. I am, as the screen says, a partner in the litigation department of Freeths LLP. And for my sins over the years, I've done a number of cases involving the definition of a mineral from a legal perspective, as well as coal mining subsidence and other mines and minerals related matters. This is a huge topic, and I'm afraid what I'm going to do today is very much go over a broad area of the surface and not down into too much depth. So there will be a number of massive generalizations. And I'm sure that there are people sat out there who will be thinking to themselves, well, that's not right, because that's a massive generalization. Hopefully there'll be some time at the end. It's the first time I've done one of these completely remotely, and so I can get no feedback, I'm afraid. So I hope you won't be too perplexed, and I hope you won't be too bored. I'll crack on and let's see where we get to. The first couple of slides are actually summarized in the information you were given for the seminar, so I'm not going to spend too much time on them. It's a bit of background about the issues arising and the history of minerals, and the fact that the legal definition of a mineral is somewhat uncertain. And I'm going to concentrate on a couple of the main tests to show you that, unfortunately, after many hundreds of years of argument between lawyers, ultimately, the answer to the question is, it all depends. A very brief history of land in this country, and again, I apologise for the fact that it's somewhat general. The starting point, everything in the land and on the land belonged to the Crown. The Crown could do what it wanted with it, and one of the things that it did was it set up a number of lords of the manor. So they were kind of sub-crowns in various areas. And they had certain rights over the land, but also so did the people who lived on it. This wasn't a property interest in the way that we understand it today. There was a bundle of rights. Some belonged to the lord of the manor, some belonged to the people who lived on the land, and they owed each other certain obligations. One of the things that the lords of the manor owned as part of their manorial rights was the minerals, and the fact that there are manorial copyhold minerals still has a big impact today. It was then decided almost as a policy that this system of land ownership actually held back development of the land, and so the concept of freehold was developed and has gradually taken over most of the land that we now live in. Most areas of manors were subject to enclosure acts or enclosures agreements, and what they did was they sold, they went round, evaluated the land and decided what it was worth. They then sold it to the highest bidder. They got the surface. The lord of the manor usually either retained the mineral interests or was compensated for the mineral interests they were giving up in other ways. Land registration started in 1925, and that was primarily of freehold titles. It's supposed to be the definitive register of ownership, and for most of the surface of the country today, it probably is. Only now, 100 years later, are we starting to deal with mineral ownership, partly because it's so complicated. In terms of what land ownership gives you, if you are the freehold owner of everything, of the surface, then in theory, you own it down to the centre of the earth, up to the moon. Now, of course, For aircraft, that creates a few problems, so there are licenses. Air rights are still important for things like cranes, flyover licenses. What happens with minerals is that it is acknowledged that there are seams and strata of subterranean materials which have a separate value. And you can sever those from the surface. So you can have a surface interest and a mineral interest that could be 5 meters down, 10 meters down, 300 meters down. Coal, of course, was one of the big ones in the last century. That goes back to 1888, and that's where the law can be summarized. Mines and minerals are not definite terms. They're susceptible of limitation or expansion according to the intention with which they are used. First appearance of the test, which basically says it all depends. There are three main types of establishing mineral rights. Many deeds contain exceptions and reservations. What this usually means is that somebody is selling the surface interest, but retaining the mineral interests underneath. There's an example there from a 1921 deed, which in some ways is quite typical. So it accepts and reserves to the seller the mines, beds and seams of coal and ironstone and other metals and minerals within and under, etc. So you get sometimes a short list of things that are expressly reserved. Sometimes that's a long list, but the one that usually causes the trouble is the bit after that, and other minerals, because what that means, nobody knows until a judge decides. Then there's manorial mineral rights, former copyhold land. One of the rights of the Lord of the Manor was to the minerals. Each Enclosure Act is different. The rights that were involved in each manor is different, but they still exist. I acted for a landowner, well, I say a landowner, a buyer of manorial titles who would buy up manorial interests because there was near surface clay. He would then, when anybody tried to build a house on any of that land, he would say, well, if you're going to dig into those foundations, you're going to be taking out my clay, and that's a trespass, and I can stop you building that house. But of course, if you want to give me 2 or 3 grand, I won't do that. A big developer decided to take us on and actually applied for a declaration that clay wasn't a manorial mineral for these purposes. They were quite astonished because we had actually done an awful lot of historical and legal research. So instead of us buckling under, we actually sent back a huge amount of evidence about the history of the area. And in the end, of course, as with most of these things, it settled out of court. The other one is the Mining Code, which dates back to the 1845. Now, this is the first real example of compulsory purchase in this country. Canals and railways were deemed to be a good thing, but of course, they cross a huge number of surface areas owned by different people. So it was decided that there had to be a way of acquiring land for those purposes, and it was done through Acts of Parliament. But of course, the people who are in Parliament are also the big landowners, and they also have extensive mineral rights, which are very valuable. The Mining Code is a codification of what started to happen in the various acts, whereby if infrastructure, and now of course it includes things like gas pipes, sterilizes minerals that somebody or the mineral owner wants to work, they can say, we want to work those minerals. The infrastructure owner can stop them, but only on the basis that they pay compensation. And again, the wording in the various acts and in the Mining Code is quite vague, and it's the other minerals which often leads to the litigation. Many occasions, of course, it's just dealt with. There's a fairly standard price for various things. The mineral owner and the surface owner just agree what the compensation will be. Right, I'm going to talk about a few cases, not all of them by any means, but there are a few to highlight the main areas of interest. The first thing to remember is that almost all of these cases end up in a situation where one judge will find that something is a mineral and somebody else will find that it's not. don't assume that these are the definitive answers to these questions, because they all are all about substances which both have and have not been found to be a mineral in particular circumstances. So this was a fairly general reservation, all mines and minerals. So anything that could be a mineral was reserved. The issue was over china clay. The decision was, in this particular case, yes, it was. And the decision was the first part of the bullet point. Minerals includes every substance under the surface of the land which can be extracted for profit unless there is something in the nature of the circumstances to restrict the meaning. So that's pretty wide, but it has its own problems as well. One of my experts used to say to me all the time, well, that's all very interesting, but does that mean that coal ceased to be a mineral when it had to be subsidised by the government and couldn't be extracted for a profit? This was a reservation that came through from the Lord of the Manor, and the Lord of the Manor had extensive rights, so that was part of the decision. But ultimately, there was no express power to quarry. So it was decided that whilst the clay was a mineral and couldn't be trespassed against, it couldn't be worked either. So what happened, almost certainly, as in all of these cases, the owner of the china clay and the people who had the surface did a deal, and money changed hands. What was interesting about Hexton Gill was that Lord Justice James obiter, which means it wasn't part of the final decision, but it was sort of an aside and a comment, gave a very different definition of minerals. Mellish was the lead judge, and that's his version of events. James said, if I wasn't constrained by previous cases, what I would say is that what is meant by mines and minerals in a grant or reservation is a question of fact. And that's interesting because now, of course, to go back to facts in 1872, you usually have to use expert evidence, and expert evidence is not fact evidence, it's opinion evidence. What these words mean in the vernacular of the mining world, the commercial world, and the landowners at the time of the grant. That's what we call the vernacular test, and that has become the main test of how judges decide what is and is not a mineral. I've emphasised a few things there, both vernacular, but also at the time of the grant. That can be critical because what it means is if you are going back into manorial times or a very old reservation, you have to look very carefully at what was around then. So you're doing lots of historical investigation, which is both time consuming, expensive, and depends on the records which are available, many of which, of course, have been destroyed. The significance of that, for example, one case that I worked on, there was an argument about what was the relevant date because there'd been a contract, but certain things hadn't happened, and the contract was signed much later than the workings had begun. And there was about a 15-year difference between about 1870 and 1885. In the interim, scientific advances had meant that a particular substance which hadn't had an industrial purpose before suddenly became very valuable. So one of the things that the experts did agree on was that if it was the earlier date that was relevant, then under that particular test, this wasn't a mineral. If the later date was relied on, it was, because of the scientific advances and the fact that it could now be used in an industrial process. The vernacular test was approved by the House of Lords, so it ceases to be obiter and becomes something that's adopted by the senior judges. The next one was about sand and gravel. Again, there are cases where sand and gravel has been held to be a mineral. This is Waring and Foden. I'm not going to read it all out. The slides, by the way, will be available from Clive. So if I do rush through them quickly, you do get the chance to have a look at them at your leisure later. And again, all mines, minerals and mineral substances and full powers of working. And powers of working became increasingly important following Waring and Foden. The decision was that sand and gravel wasn't a mineral for these particular purposes, and they introduced another test. And they talked about it must mean substances exceptional in use, in value and in character, and must not mean the ordinary soil. And I've put rock in there because in later cases they use the word rock, the ordinary soil or rock of the district, which if reserved would swallow up the grant. So they say that, which is not the vernacular test, and then go on to say, oh, but we'll apply the vernacular test as well. In instance, the whole surface effectively was sand and gravel. So they were saying that if sand and gravel was intended to be a mineral, the surface owner would effectively have nothing. And therefore, in the context, that suggests it couldn't be a mineral for these purposes. The Earl of Lonsdale, 1982, again, lots of historic documents. It was all about conveyances and leases from the Crown. And the interesting thing here is it says mines and minerals down to the bottom of the coal measures. So it didn't include things deeper substances. They applied the vernacular test and decided that oil and natural gas were not within the definition of mines and minerals under the vernacular test. This case is important and significant because it's constantly referred to later in all of the other tests. It set out 7 pointers to be considered. Now, I don't know about you, but if you've got 7 pointers, the reality is almost always 3 of them will go one way, 2 of them will go another way, and 1 of them won't make any difference. So almost the number of things that they're prepared to look at makes it more difficult to make a decision. Some of the key things that came out of Lonsdale, unless it's clear from the document. Now, that has become more interesting. I'm going to talk about a case later about stone. And again, stone has been held to be a mineral in certain cases and not in others. I'm also going to talk, I'm also involved in a case involving clay, where there is an express reservation of clay. So you would have thought that for those purposes, clay was included within the reservation. However, it is being argued that because of the vernacular test, only certain types of clay are included within the reservation. So we talk about how you apply the vernacular test, maybe derived by direct evidence or by inference, but you have to consider all the circumstances. Number 3 and 4 are some of the pointers. Consider whether the substances are exceptional in use, in value and character. That caused quite a lot of debate in other cases. Is it a different test or is it part of the vernacular test? Exceptional suggests a very, very high bar. Is it just the flip side of it's not the ordinary soil of the district? Is it just something other than the ordinary soil of the district? A later case suggested all it means is it has to be something special. Well, that lowers the bar a bit, but special is still special. The state of knowledge of the relevant substance of the date of the grant. And as I say, the industrial case that I mentioned before is part of that, and powers of working. 4 is one that people quite often forget. When you look at a document, that is what you look at. What you try to do is you try and decide what the parties were trying to agree from the words of the document. Now, it doesn't actually matter that this is now a substance that nobody ever thought of at the time. You don't call evidence of what they believed they were transferring. You just look at what the words say. Right, now this is the most modern case. I've been slightly nervous about talking about this case because it went to the Court of Appeal. The Court of Appeal heard it at the end of June and July, and it was always possible that by now everything I was saying would be completely wrong because the Court of Appeal would decide something entirely different. The way this came about, and this is gossip, so don't quote me, it's from things I've heard in the industry and a few hints in the judgment. The surface land is owned by the National Assembly for Wales, and it's been managed for many years by Natural Resources Wales for forestry. Before then, it was also used for forestry. So the history of what has been going on the land goes back many, many years. There is an estate which claims mineral rights over large tracts of land in northern Wales. That's not unusual. The Westminster estate made a lot of its money in the 1900s from its mineral estates. The Chatsworth estates, the Welbeck estates, estates all over the country had very, very extensive mineral rights. The church commissioners still own a lot of minerals. The Crown still owns a lot of minerals. Many, many years ago, I used to act for the Crown estate, and I was involved in a case which involved a grant signed by Queen Elizabeth written in Pigden Latin. What happened was somebody wanted to put a wind turbine up. Now, wind turbines, as you probably know, have deep foundations. So the issue was, could National Resources for Wales give them the right to dig into foundations? And once somebody's asked the question, it becomes a bit more complicated. And there became some evidence that perhaps they didn't. Now, what they had been doing, and their predecessors had been doing, was using little local quarries to extract mudstone to use to build the tracks and roads and for maintenance purposes on the forest. That's not unusual. And again, it dates back to enclosure acts, whereby quite often stone quarries were reserved to the local community for the use in the roads. So you could go and collect some stone and put it on the roads. What you couldn't do was go and collect stone from the same quarry and use it in your garden. So again, it's not an unusual historical situation. They approached the potential owner of the minerals, which was Wynne-Finch, and said, look, there's an issue here. Perhaps we ought to come to some arrangement and we ought to pay you some money for use of the mudstone. Not that we think you own it, but we think it's sufficiently unclear that we ought to have some clarity. So as ever, it's about money. And they couldn't agree the price. So it ended up in a major piece of litigation. It said, was mudstone an intermittent sandstone a mineral? If it was, it belonged to the estate, and therefore NRW should be paying to use it, or indeed could be prevented from using it at all. And if not, it was part of the surface, and NRW was actually the surface owner. Now, there's a quirk in that, which I'll mention later. But for historians in particular, it's an interesting case because it wasn't just one title. The historic title went back many, many, many years. And they ended up dividing the arguments into 4 separate categories. Category A is a fairly standard reservation. 1919, all mines, beds and quarries, and that's potentially an important word, of coal and ironstone and all other metals, stone and minerals within and under. So that looks like an express reservation of stone. I do wonder if that hadn't been there, the argument about money might have been resolved. Because the question then becomes, we have an express reservation of stone. Is mudstone stone for these purposes, or is it a mineral for these purposes? 1864, that was a Crown grant, and typically of Crown grants, it reserved mines and minerals, but it did them in a very, very wide way. It didn't give any other express reservations. It just said all mines and minerals within, upon and under. Then there are a whole series of private agreements to do with the surface of the land and what rights people had over them. Again, all mines, minerals, stone and other substrata lying within or under. And there was an interesting subtext to that. All the mines, minerals and substrata within, upon or under, and also all the estate, right and interest of the Queen's Majesty in and to the soil and surface of the piece or parcel of open, common or wasteland. Now, common and wasteland are back to manorial rights, plus there's also a rule of construction which says if you're dealing with the Crown gets the benefit of the doubt. And then there was category D areas which arose out of the 1861 Enclosure Act. Now, what happened under the Enclosure Act was there was an act passed to say we're going to enclose this area, and then inspectors were sent in and made an award determining who would have what rights and interests. And then there were auctions and parcels of interest were put up for sale. And it said in many of the awards, nothing herein contained shall prejudice, lessen or defeat any right, title or interest which the Lord of the Manor as in or to any mines, ores, coals, metals or minerals whatsoever in or under the said wasteland. So again, no specific mention of stone, but a very general reservation of interests. And categories were treated quite differently. It was held, whilst the estate owned the minerals, notwithstanding that there was an express reference in those deeds to stone, mudstone was not legally a mineral. It didn't have sufficient value, notwithstanding that it was being used for a purpose, and there were issues about, was it the ordinary soil of the district? Category B, which was the very wide all mines and minerals, this was a Crown grant. So again, it turned on the rule of construction that said that Crown grants are interpreted in favour of the Crown. A narrow interpretation of minerals was appropriate, which didn't include mudstone. That was an inevitable conclusion, given the conclusion in relation to categories A and D. And as I say, I think if they'd only been litigating about the wide general issue, the litigation might not have happened at all. Category C was interesting because what it decided was the original agreements which were relied on were about interests and use of the surface, and they weren't such as to amount to an express reservation of the minerals. So the minerals had never actually been severed from the surface. All that the recitations in the deeds had done was say, we're not giving you any interest in the minerals. It didn't actually sever the minerals from the surface. It just said you can't use them. Now, following those agreements in the 1850s, there had been a whole host of other agreements which had assumed that the minerals had been severed and proceeded on that basis. And the court said that's not relevant. If the foundation is shaky, you can't say that something built on the foundation itself achieves something which the original deed didn't. So the estate actually still owned the surface, except that because of what they had been doing on it, NRW and its predecessors had actually acquired a title by adverse possession, by possessing it without the permission and without payment to the estate. Now, I'll talk a bit more about adverse possession in a minute because it's quite interesting, but there wasn't a lot of evidence of adverse possession here. What the evidence was that the land registry had registered them as the surface owner. So the judge more or less concluded that the land registry must have been satisfied that at some point they acquired the title to the surface by adverse possession, and therefore they excluded any interest in the minerals of the estate from that. That's one of the things that I think will be looked at on appeal. And another slightly interesting thing about that is it's very different from another recent case in which a judge said, well, I know there's an entry at the land registry, but all that is the opinion of somebody at the land registry looking at some documents. It's not the decision of a court. So two very different approaches to what a land registry title means there. I'm now moving a bit away from what is a mineral to talk about adverse possession. In relation to three of the categories, the judge held that by using the mudstone for its own purposes, without the estate objecting, it had acquired ownership of all of the mudstone within surface area to a depth required for activities undertaken by NRW on the relevant forested area. Bear in mind, the judge doesn't have to make this decision because they've decided that mudstone isn't a mineral. He says, but if I'm wrong, I think they own it anyway. Now, the potential massive significance of this is that usually to acquire a title by adverse possession, you have to possess it. And the classic is you fence in an area and nobody bothers you for 12 years. So you've excluded all the world very obviously, and nobody's challenged you. The potential implications of this decision are that you can dig down and quarry over in one area, and by doing that and by using the mineral from it or the material from it, you acquire by adverse possession the same substance several miles away. Now, that's something, the implications of which may have to be worked out over time. It's very different from the old law on adverse possessions on minerals, because of course, for those of you who actually watched Poldark, most minerals trespass happened underground, so you didn't know about it. So there were very specific rules about the compensation that could be paid to a surface owner where an adjacent owner had trespassed onto their minerals. But that was all hidden. The crux of adverse possession on the surface is that it's got to be open, so somebody driving past can see that you've excluded all the world. So this is a very different decision to most decisions, both on adverse possession of minerals and adverse possession generally. Just before I leave minerals, I'm going to talk a bit about the problems that the vernacular test creates. The fact that he talks about the date of the grant means that you're very often going back certainly tens and sometimes hundreds of years. That means it is hugely expensive. You require a huge amount of historical research. One case I did, we had a mineral surveyor who was supported by a local historian who spent months going up and down the country to estate archives looking for documents which, for example, some of which we'd found in the Nottinghamshire University archives, but which were unreadable, but we had to find in another estate archive somewhere else. There was a geologist, which is where I met Clive, as it happens, and there was also an industrial historian. So by having to go back, you make it a very, very difficult process. And certainly I'm in awe of some of the research that was done in the NRW case, because it was so extensive and so much had to be looked at and so many deeds and documents considered. Certain advantage in that the estate, of course, had its own records, and those are that's very often the case. One of the parties is one of the major estates who, by their nature, keep records forever and keep them in quite good order. What's the next big thing? Well, geothermal lithium is quite a big thing in the minerals world generally, and I suspect it's going to be quite a big thing in the legal world as well. First question, is it a mineral? Well, firstly, I've not been instructed on any of this and I've not looked at any of the material. I throw up my hands and say, well, after what you've just listened to about the vernacular test and the time of the grant and various other things, what do you think? It also raises questions about subsidence and nuisance. There is a brine case where, talking about adjacent properties, there were salt beds and these were exploited by pumping water down, pumping the brine back up. Now, of course, what that did was it affected the salt beds and it affected the support. And what happened was that a neighbouring property subsided. So the question there was, is extracting the salt, does that create a subsidence? Well, it created the substance, does it create a nuisance? And the answer, both in that case in relation to the salt beds and also in the subsequent case relating to silt, was that yes, it was a nuisance, and the operator had to pay compensation for the subsidence, and arguably there was some argument about whether or not there could be an injunction granted to prevent the operations altogether. Contrast that with some cases purely about water, where you extract water from underneath your own land, but of course the reservoir extends into an adjacent land. The adjacent land loses support and subsides. Well, apparently that is not an actionable nuisance. You're entitled to use your own water, you're just not entitled to use your own salt. Trespass. A case involving Bocado, which was a petrol case, was one where, again, you drill down on your own land, and then at a great depth, you drill horizontally into your neighbour's land. Now, part of the argument there was, well, it's 3,000 feet down, so that's too deep. This stuff about you own the land down to the surface of the earth doesn't wash anymore. Not a great argument, and the judge pointed out the obvious, which is the nature of minerals law changes over time and changes in technology. And if you can go deep enough to work it, then you must be able to go deep enough to own it. Somebody must own it, and obviously it's the person under whose land it is. You can't say that because I own the neighbouring land and because I'm the person who's prepared to work it, I therefore own it. That again was something of a Pyrrhic victory though, because although it was decided that was a trespass, the application for an injunction, which could have given rise to a lot of valuable ransom payments, didn't happen. What they said was, but the compensation in this particular instance is based on what would the normal cost of a license be. And funnily enough, in that case, it was comparatively minor. So you come back to, it's all about the money. That's all I was going to say. As I say, it's a very, very quick run through about a lot of complex areas. Happy to talk to anybody afterwards. You've got my details on there if you get the slides. Only an introduction. I hope it's been interesting, and thank Clive for the opportunity. I think Alex is going to, or Clive is going to moderate any questions.
Well, thank you very much, Stephen. That's opened my eyes to a lot of things I knew nothing about, and I think I've got all sorts of questions coming out. But the first one's coming up is, can you clarify the point about swallowing the grant? If the minerals reservation includes the right to open up the surface and to work from the surface, which in the 21st century is now pretty much the only way to work minerals, does that counter any pointer that substances near the surface can't be minerals?
Well, I'm afraid the answer to that is it all depends. Waring and Foden had a big influence because the restriction was by underground workings only, and that was taken as a very, very heavy pointer towards a substance that could only be worked from the surface, not being a mineral. But for example, in the clay cases that I was involved in, it wasn't so much that the clay covered the entire surface area, but that it outcropped in particular areas. So the clay was both at depth and near the surface, and we argued that we're not asking for something that, if we were to work it, would destroy the grant and mean that the surface owner had nothing. We were just asking for the areas where it outcropped. But of course, if we could stop them working those areas, it had an impact on how they could design the development. So the answer is, yes, it's quite a powerful pointer one way, but it won't get you over the line. It all depends on what substances you're talking about, the exact wording of the grant, and powers of working is a powerful pointer, but it certainly isn't everything. You always, always, always have to go back to what was intended, what was known at the time, what would people have said at the time. And as I've said, sand and gravel have in the past been classed as minerals. Personally, I don't think that is likely to ever happen again. I think the broad thrust of the law is, particularly when you're looking for other minerals, it's to restrict things. But then you get something like a new development and something becomes valuable for a purpose for which it wasn't valuable before, and things change again.
We've got a couple in, I think, that relate to each other. From Richard, apart from the classification or otherwise of lithium-bearing brines as a mineral, the mobility and hence uncertain sources of them also presents an interesting dilemma. And that's followed up with lithium is noted on the old mine plans of tin and copper as being within the mine water. The lithium is within the geothermal water, then mine water in the 1770s, 1890s in Cornwall. As it was noted, whoops, sorry, my screen's moving. Would it be a dissolved mineral, or as there was no known use at that time, would not? An interesting case.
Well, absolutely, it's an interesting case. I'm sure there is going to be, whether or not it gets to litigation, who knows? Because usually these things are about money. And if the various owners can come to an appropriate agreement about valuing the uncertainty, as opposed to the absolutely certain costs of, certainly in a case like this, hundreds of thousands of pounds in litigation, whereby you also run the risk not only of losing, so there's the litigation risk that you don't get the result you want, but you also run the risk that you might have to pay the other side's costs. There has to be an awful lot of space between the two in terms of the money they're prepared to pay and the money they're prepared to accept to make the litigation worthwhile. If it flies, it will be fascinating, and quite frankly, there is enough money in it that it might fly.
What happens to legal decisions when the economic goalposts change that define a mineral extraction's viability?
Well, again, I'm afraid we come back to it all depends. Bearing in mind that you always go back to the date of the grant and what was known at the time of the grant. The new developments, it depends when they happen. I mentioned the change in because of the grant of patents for use of a particular substance in industrial processes, and that would certainly have affected that decision. I think the other thing to bear in mind, particularly when we're talking about, I was going to talk about near surface minerals, but it only really relates to instances of the mining code, where of course planning is critical in the mining code, because you have to intend to work it, and very often that requires you at least to be looking at acquiring planning permission to work it. And if there's zero possibility of you obtaining planning permission, does that mean there is zero possibility of you being able to work it and therefore having the intention to work it? You know, planning can be important in other contexts as well, but the title itself shouldn't really look too hard at planning.
Duncan, my understanding has always been that life got particularly complicated during the iron and steel age, especially in respect of limestone, which became a great interest for steelmaking rather than just as a building material or the common ground of the area. Would you have any comment on this, please?
Absolutely, and indeed, funnily enough, the case where I mentioned the difference in the timing of the grant was about limestone. It was about its use as a building stone, and it was about the possibility that it suddenly became extremely valuable for industrial purposes. So we come back to, it all depends. Had the grant been 20 years later, there wouldn't have been any issue about it.
I've certainly got one, and I think the answer to this will be it all depends. But as a geologist with no legal background, are you able to sort of give a couple of points that would be good for us to consider just when we're doing our day-to-day job before we call in the experts?
Somebody somewhere has got to look at the titles, and whether or not that's a lawyer, who knows. Part of the problem, particularly with manorial titles and copyhold titles, is that the title registers aren't definitive. What they are trying to do now is they are trying to persuade people with manorial mineral interests to register them, at the pain of losing them if there's a change in the surface ownership and you haven't registered your minerals. And certainly we are seeing some of the bigger estates engaging in programs where they're writing to people who own a terraced house in the middle of Newcastle, just saying, oh, by the way, we're going to register the fact that the mines and minerals under your property are accepted. What would you look for? Well, you're the people who decide what in your world is a mineral. Just don't assume that because in your world what you found under the surface is a mineral, it is in everybody else's world.
And another question coming in. My impression is that the wind farm industry has not been impeded by concerns about mineral trespass. Is this your impression too? And if so, is that because the minerals are generally too deep to be affected by the wind farm foundations, or do wind farm developers not think about that issue?
I have to say, there are people I know of who are a much better place to answer this than me. I haven't been too involved in any wind farms, but I have certainly seen inquiries about wind farms where people are working out, all right, how deep do we have to go? Let's take some boreholes. What does that mean? Does that mean that we only have to deal with the surface owner or elsewhere? What, of course, I don't know, because I'm not one of those people who's involved in this, is how often people are paying. It's just a cost of doing business. And as I say, if you're doing a building site and it's got 50 houses on, if you can pay £2,000 a plot for something you don't believe you have to pay at all, but for £100,000 you get absolute certainty. Alternatively, somebody can spend hundreds of thousands of pounds establishing you're wrong. Similarly, if you're the guy who's only paying £2,000 for the house, you're certainly not going to litigate about whether or not the mineral title is a good one. So I suspect the answer is there are deals being done, but I honestly couldn't say from experience.
And I know Clive has a question.
Yes, Stephen, fascinating. I'm sure there's a lot of people out there sort of like really interested in this, and thank you very much for allowing us to circulate your presentation as well. I think we've got a lot of people interested. One thing that when I was involved with working with you that I often thought, and we probably discussed, is that the difference between the sort of geological and the scientific definitions of a mineral and what the law would say, the legal, what sort of weight do you think science or geology has in this case? Does it have any weight, or what's your impression of that?
It's interesting, isn't it? You start from, and many judges start from, that they were told when they were 6 years old, animal, vegetable or mineral. It's not just the law and scientists who have different views of what things are, and things do change over time. I mean, you may remember in that case, and as I say, it was about limestone. We had an expert on the other side who, was part of his CV of his mineral experience, talked about limestone, whilst at the same time arguing that it wasn't a mineral. Now, of course, the argument was, when was it a mineral, and by what test is it a mineral? And the position is very different now. So there is a recognition that things do change over time.
Good stuff. Thanks, Stephen. Alex, I think we've run out of questions, unless you have any more questions to ask.
No, I think that's it. Well, I've got plenty, but I think I need to think about them before I ask them, if that makes sense. Thank you very much, Stephen. That's been really, really interesting and eye-opening. I'm looking forward to go through the slides again, certainly. Thank you for your time, and thank you everyone for your questions. Okay, well, as I say, thank you for having me. Everybody's got my details if there are any follow-up questions that they want to ask. My answer isn't always, it all depends. What it usually is, I need more information before I can talk to you. But if you've got a particular problem that you want to run past me, or just where do you start? Because I appreciate that unless you've been through these things before, the where you start point is actually quite difficult. Thank you very much.
Great, Stephen, thank you very much. And to those that are still listening, this presentation will be made available as a video on the YouTube channel, the EIG YouTube channel, and we will have another EIG webinar in a couple of months' time. So I think we're still looking for a speaker for the next one, Alex. So I think if there's anyone out there who's interested in following the great act that we've had today with their own presentation, please get in touch with us, and next time maybe you could be appearing on this screen. And with that, I think we'll say cheerio, and thanks again to Stephen, thanks Alex, and hopefully we'll see you all the next time. Thank you, goodbye.
Thank you.
Okay, cheerio then.